Welcome to Subramani. Please subscribe, please hit the bell icon. I need to have more subscribers. Just kidding. But yeah, a few days ago on Twitter, I had asked a question as to when should you make your will, and I had said only good and correct answers, not some stupid answers I didn't want. So I got good answers. So I'll share some of this. So Umesh Ikhe says, as early as you can. When you don't want to leave your family, go through all the hassles to identify all the assets and get them transferred. When you have assets in your name which are valuable. Rishi Kothari says a will can be made anytime, but ideally a will can be made under the following circumstances. Once you have started earning, once you have inherited something from an earlier generation, once you have a young family, once one has a lot of liabilities going through midlife crisis, once you have reached retirement, one has issues related to health, one has to protect their legacy, one has to protect one's wife's interest from kids and family, one has built a proper business and has to protect the business, one has to ring fence the assets from raiders and incapable progeny, one has to do optional tax planning, one has to foreign assets ownership and comply with their with their laws and tax efficiency. It is thus important to have a will rather than die intestate. Rishi Kothari, I agree 100% with you, but you have still not answered one question: when should you make it? So from Rishi Kothari's answer, it looks like when you have a lot of assets, when you have a running business, when you have international assets and all that, you should make your will. Let me answer it very simply. The minute you buy real estate, or rather the day you register the real estate, you should register your will. It is not about anything, it's nothing to do with age. I have a cousin who died at the age of 64. I think he died without a will, but he had not bought a house. All he had was mutual funds and insurance, etc., and all that passed on to his wife very peacefully. His mother had a house in which he was staying where his wife was the nominee. So that when his mother died, his wife got the real estate, right? So the answer is very simple. The day you have real estate in your name, you should have a will. Right, don't delay, because if you die intestate, there's a big hassle going from the municipality to the registrar, etc., etc. You will roam around a lot, you will spend a few lakhs, and with the stress that you can't, you don't know whether you will be able to live in that house if something happens. So the argument which people give is to say, oh, but my wife is my joint holder. Does not mean anything. If me and my wife are joint holders, one, it is very inefficient from a tax point of view. Secondly, I own half and my wife owns half. I can give away my half to my brother and my wife can give her half to her sister. Anything is possible. There is nothing which says it's not an either or survivor like in a bank account. If I and my wife are either or survivor in a bank account, and if I die, the whole account belongs to her. Simple. It's as simple as that. There is no question of somebody else coming and saying it belongs to me. Of course, I'm not talking of legal cases, I'm talking of ordinary situation. But when the husband dies, it does not mean the house will automatically go to the wife. Yes, it does today in theory, because the society will just say, okay, now you're the sole owner. But if you try to sell, the buyer or the buyer's bank will ask for ownership papers. So when I and my wife own one property jointly, we still have to make a will where I have to say, if I die, my half belongs to my wife, and my wife has to say, if she dies, her half belongs to me. That will is necessary. Or both of us can say my half goes to my daughter and she can say my half goes to my daughter. So my daughter will get the whole thing. But that has to be made. Don't assume that because you're joint holders, it will automatically go from A to B or B to A. It does not happen that way. You have to make a separate will. If all the other assets that you have is just mutual fund, insurance, bank deposits, etc., it will all get transferred by a simple nomination. You don't need a will. Though it is ideal to have a will, it is not necessary to make a will, because it will be pretty seamless in all the movement. You will have a form 2A or a form 2B or a form 2C to transfer it. That's about all. You wouldn't have too much of a hassle. Yes, the person who is getting the assets may have to go and get their KYC done. They may have to get their signature attested by the bank, something like that. But that's all. It's nothing. There is no other legal formality required for movable assets. But immovable assets are different. So if you are in a cooperative society in Mumbai, I will not even talk of Navi Mumbai, I'll talk of Navi Mumbai separately, but when you have it in Mumbai and your flat is in a cooperative society, ideally you should have a will, you should have a nomination. And if you are doing it very differently, for example, if you are saying everything will belong to my son and nothing will belong to my daughter, it is better to even have a no objection certificate from the daughter when you are alive, because the daughter may not sign the no objection certificate if your son or son's widow were to go and request her to sign, and they may not give. So in the society you will not have a problem, the society will transfer it. However, when your daughter is trying to sell it, she will have a problem. So if I have given my house to my daughter and not given anything to my son, he can go to court, he can dispute, he can say my sister did something and got fooled my father and took the whole thing. Those things can happen. So it's better to have a clear will, and in the will say that I spent a lot on my son's education, therefore I am giving this flat as a security to my daughter who has decided not to get married. Any of those things, you can put all those explanations, not that you need to give any explanation because you're the sole heir. But if you die intestate or somebody challenges your will, then the court will see why something has been done, and then say no, we will give it away equitably, and so your son and daughter will get half. So all those things will happen. So if you have a detailed, well written will, and if you have the nomination given to the society and the NOC of your children and their consent, which you should take when you are around, then that is a complete passage of title. What happens? So many people might argue that, look, my father died and the house got transferred to my mother, and after my mother's death it came to me very peacefully. Yes, it came to you very peacefully, but try selling it. If the husband has died and the house has come to the wife without a will, just through a nomination, she will have to prove how she got it, right? How her husband got it and how her husband gave it to her. Well, there is no will. So what if the children dispute it tomorrow, right? So all those fears will be there in the mind of the buyer. And when I say mind of the buyer, I mean the lawyer of the buyer's financer. So if I were to go and buy a house worth 1 crore, where I don't check all this, I might just go and sign and buy. But if I were to buy a house of 1 crore, where I was borrowing 30-40 lakhs from, say, Axis Bank or Kotak Bank or HDFC Bank, anybody, they will ask for the details as to how I got that, how the seller got that property. So then there has to be proper documentation. A sold to B, B sold to C, C died, and therefore Mrs. C inherited it. And what is the documentation for this? That whole lineage of documents they will ask, because the financer does not suddenly want to find that the transfer is not right because the children were ignored and the children are now coming and disputing it. Why would a financer take that risk? So I am taking a risk. I go and buy a property with, and my foolishness, tomorrow if it is in court, I have to struggle. So I didn't even know that I have to ask for all these documents, but a banker knows. So banker will ask for all those documents. So therefore making a will is important. So again, Anand says, whenever you have significant property in your name, no, none of us ever have significant property. We just have a property. Whether it is significant or no depends on how much of other assets we have. So suppose I have a house costing 3 crores. Is it significant? Well, if my equity assets are 300 crores, then this is not significant, but this is big enough, right? Why would I take a chance with any asset? So when you have property in your name, you have to make your will. That's a good idea. Anand's world. Manan Mankar says, the day you start earning, whatever is the amount, doesn't matter. No, not really. The day you start earning, you got a lot of other priorities. You have to start your SIP, you will have to do your KYC, you will have to open your multiple bank accounts, whatever. You will, writing a will is the last thing in your mind. But yes, it's a good answer to say as soon as you start earning. But I would think as soon as you start, as soon as you buy a house, right? You think of buying a house, you start and you buy a house which maybe you paid a 5% or a 10% under down payment, not a big amount, but whatever it is, if you have real estate, right? So you have to make the payment. As soon as you have something to bequeath, yeah, saying this experience when someone dies without a will, or it is terrible experience for the heirs. Yes, I agree, but if you have a joint holder and a nomination for all your mutual funds, insurance companies, you have proper nomination, then not having a will not hamper you. Pinasef says, now then somebody else has also said immediately. Shankar says, waiting for the answer, as I don't know how to predict, and when nomination must in every financial product. Yes, nomination is must, but nomination alone is not enough for a real estate product. It was yesterday, but next time is today. Yesterday you should have made it, but if you make it today, it's fine. I agree with you, but if you don't have real estate, it won't really kill you. But if you have real estate and you have not made a will, also when you maybe you made a will when you were 22 years of age and you were not married. So you made a will in which your house and everything, whatever you had, whether it was, I mean, obviously you would have paid an EMI and bought a house, but that time the nominee would have been very likely to be your mother. Right, so now you have to make a will, change the nomination, and make sure that the nomination and the will and everything is in sync with each other. Don't create the problems. Of course, the will prevail, but then if somebody else goes and says, why did the will prevail, and create that kind of a hassle. So you don't want to do that. As soon as you have 2 heirs, no, as soon as you buy a house. 5 years after son's marriage, I can't understand the logic. So if you trust your donies gifted to them, as it can be challenged even after your death. ASAP, if not done so, and register it. I agree. Sundar Raman says that by passing on, you immortalize your earnings, your principles in life. And there are many people who do that. They come to, they come into the world, they do all these things, but they don't have enough documentation to know, for people to know where they are staying, what they are doing, etc. So it's a pretty mess. The amount one starts earning, make a will, etc., etc. So I think more or less covered that you should make a will as soon as you have real estate. Of course, even if you have make it before you have real estate, that's fine. But the day you register your real estate, you should also register your will where that real estate is being mentioned. Thank you.